Hello everyone, this is Shiv Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. So in this today's session, I will be discussing about the doctrine of public accountability. Starting with the accountability, the meaning of public accountability, then going through the doctrine of public accountability and evolution of this doctrine. Further in the next video, that is the part 2 of this video, I will be discussing about the need for the doctrine and RTI as a tool to enforce the doctrine and other parts. So let us start with the basic term, that is accountability. So accountability means being able to provide an explanation or justification and accept responsibility for events or transactions and for one's own actions in relation to these events or transactions. Accountability plays a particularly important role in the public sector. It is about giving an answer for the way in which one has spent money, exercised power and control, mediated rights and used discretion vested by law in the public interest. It is fundamental to our system of government that those to whom such powers and responsibilities are given are required to exercise them in the public interest fairly and according to law. Now let us see what is the meaning of the public accountability. The basic aim of this doctrine is to check the growing misuse of power by the administration and to provide a speedy relief to the victims of such exercise of power. Doctrine is based on the premise that the authority given in the hands of the public authority is on the public trust, which must be exercised in the best interest of the public. In every democratic society, it is of utmost importance that the citizens get sufficient information and knowledge about the functioning of the government. Democracy cannot survive without accountability to the public. The basic purpose of accountability is the openness of the government. The very integrity of the judicial system and public confidence depend on the full disclosure of facts. Public accountability is a result of when judges act as a legislator, that is, who legislates from the bench, rather than like a customary or traditional court. It is one of the examples of the self-assumptions of power of legislature by the judiciary. Unfettered discretion is always an issue of contradiction in practical life. The concept of public accountability is a matter of vital public concern. All the three organs of the government, that is the legislature, executive and judiciary, are the subject to the public accountability. Public accountability means the mandatory to answer publicly, to report to an acceptable standard of answering for the discharge of responsibilities that affect the public in important ways. It is the obligation to answer for a responsibility conferred. The obligation to answer publicly arises as a fairness obligation whenever authorities intend something that would affect the public in important ways. Thus, the obligation extends beyond answering for responsibilities formally or legally concerned. Responsibility is the obligation to act and accountability is the obligation to report on the responsibilities. These are separate obligations. The purpose of having authorities answer publicly for their responsibilities is to let the citizens make reasonably informed decisions about the safety and the fairness of the authorities. When citizens are reasonably informed, they can act to condemn, alter or halt authorities' intention. This means that citizens have more control over what affects them. An important element of public accountability is transparency. Without it, the doctrine cannot be enforced. And by using the right information tool, we can find out the arbitrariness in the action of public authority and the rule of law. The concept of accountability is on its own does not necessarily imply public accountability. Public accountability goes hand in hand with representative democracy and its associated rights of citizens and obligations for political representatives and public officials. The ultimate value of the public accountability is that the elected public representatives and public officials are required to conduct public dialogue among themselves on what they do and intend doing. and the suppositions that secrecy of matters of public management conceals misadministration, mismanagement, and corruption. The ethical base of public accountability is the level of accord created between the government authority and the government's accountability to the public. The true function of public accountability should be not to focus on negative aspects only. So now let us see what is the basic meaning of the doctrine of public accountability. In the last decade, the doctrine of public accountability has been materializing steadily as a facet of administrative law. The development of this doctrine is the key in establishing a check in the increase of misuse of power by the government servants and provisions of a just and speedy relief to people who may have suffered at the hands of such exploitation. The premises of this doctrine is that the administrative authority's power and discretion is the public trust placed in their hands and should be exercised in realization of such conventions. Now let us see how this doctrine evolved. That is evolution of the doctrine. The doctrine of public accountability had and continues to have its growth through cases discussed and argued upon in courts. The case of Attorney General of Hong Kong versus Reid, this was the case of 1993, is one of the most illustrative cases of bribes and constructive trust. That is a judicial remedy for a party deprived for their rights due to the person holding their property through illegal means. In this case, a prosecutor appointed by the Crown was paid in bribes for buying criminal cases. With the bribed money, he purchased certain properties. It was held by the court that a gift received and accepted by the public officer as payment to breach his public duties is a bribe. Further, it was held that there existed a fiduciary duty. Therefore, the owners of the constructive trustees of the Crown. This means that the money was owed to the person who had suffered by the fiduciary and he had to hold money acquired as the constructive trust. That's all for now. Let us meet in the next session with this topic. We will continue this topic further. So please do like and subscribe the channel. Thank you.